I now call the Zoomcast open or in order.
Okay, there you are. And now, ladies and gentlemen, we'd like to invite each and everyone to bow our heads in prayer so we can begin the Zoomcast. Ladies and gentlemen, a blessed evening to each and everyone.
Help us to be. There's no reason we'll divide. We shall all understand why the good Lord is our guide. With a four-winged test, we'll pursue our quest in our little way of the day. Peace in the world, we shall not have living day. Peace be achieved, we shall not have
So with that, I would like to introduce someone who is actually a visionary capital market veteran who builds profitable and successful businesses from ground up. So ladies and gentlemen, let's all welcome Mr. Marco Isever.
Yes, and Marco Isabel may now share a screen. He has a lot of things that he's going to show us. We're very excited. Go.
Thank you all. Good evening, everyone.
Good evening.
Can you
Good
hear
evening.
me? Can you hear me well?
Yes,
Yes,
we
we
can hear
do.
you
Good
well. We
evening,
can see
yes.
your slide.
Okay, very nice. I'm delighted to speak with you this evening, and I would like to take this opportunity, first of all, to thank Rotary Club of Alabang Madrigal Business Park for encouraging us to address you. A special thanks goes to President-elect Mr. Justin Ho Go-shun, who invited me this evening. I plan to give you an overview of what EB-5 is and how it could help you to obtain a green card and ultimately US citizenship in order to live and work in the United States. Due to the limited time we have, we will go through the presentation rather quickly. Please try to follow along by watching the slides and listening to the presentation. There is no need to take any notes as we plan to make the presentation available online. Again, my name is Marco Isever. I am the CEO and founder of America EB-5 Visa, a company dedicated to connect international investors who aim to immigrate to the United States while making a meaningful financial contribution, typically in the form of a real estate investment with EB-5 issuers, typically real estate developers, looking into EB-5 as an alternate funding method for their projects. While no investment comes with zero risk, our professionals carefully evaluate both the investment projects and the qualifications of prospective investors. By way of background, I've been in Wall Street for over 30 years. Before establishing America EB-5 Visa a few years ago, I ran the Global Financial Institutions Derivative Sales Desk of the Bank of New York Mellon in New York. I'm a graduate of the Wharton School of University of Pennsylvania. Without further delay, let us jump into the presentation. In this presentation, we will cover 9 main topics that are listed in this slide. First, we will talk about what EB-5 is. We will then touch upon the reason why EB-5 might be a better choice than other non-immigrant visas, such as you might know H-1B or E-2. We will then explain how a potential EB-5 investor could obtain the necessary funds for the required EB-5 investment amount. We will then briefly elaborate on the regulations that changed the EB-5 landscape for the first time since its enactment in November 2019. We will then discuss some of the most important selection criteria to pick an EB-5 project. Many people wonder if the location of the EB-5 project matters in terms of the ultimate place they would like to be working and living. We will then give an overview of the timeline for the whole EB-5 process from beginning until the end. When the potential applicants hear about obtaining a green card, they're oftentimes alarmed regarding global income taxation of being a US citizen or a green card holder. They wonder whether that means that they will have to pay tax twice, once in their home country and then again in the US. We will diffuse all of these concerns. We will then discuss the meaning of retrogression. How does it occur? Which countries are subject to it now? And lastly, we will discuss some of the hot topics and recent EB-5 news. So let's start. What is EB-5? Congress, the US Congress, created the EB-5 program in 1990 in order to stimulate the US economy through job creation and capital investment by foreign investors. Initially, it was created as a direct investment vehicle whereby foreign nationals, that is the EB-5 investors, would invest $1 million in a project of their own, or if the project were in a rural jurisdiction or in an area that experienced high unemployment, then the required investment would be half of that, $500,000. This kind of area is called Target Employment Area, commonly known as TEA. In November 21, 2019, as mentioned before, the amounts were increased to $900,000 for TEA and $1.8 million for non-TEA EB-5 projects. It is estimated that after 24 to 30 months, the investor could be eligible for permanent residency approval for himself, his or her spouse, and their children who were unmarried and under the age of 21 at the time of the initial application. There is no restriction as to how many unmarried children less than 21 years old of the principal EB-5 applicant could apply under one single EB-5 application. 10,000 immigrant visas are annually allocated for this program. There is a debate between USCIS's interpretation of the law as to whether the law meant 10,000 visas or 10,000 investors annually. This difference in interpretation makes a huge difference in the actual number of visas that are awarded annually. The current practice, unfortunately, is 10,000 visas. Some of you might have children currently in US colleges. Some of you might be thinking of sending your children to US colleges. Why is EB-5 relevant to a foreign student in a US college? If they apply for the EB-5 during their junior year or before, they would have a good chance to secure a green card before graduation, paving their way to be able to apply for a well-paying position in their field of study and commensurate with their education. Upon graduation, many students who do not have green cards are often forced to return to their respective home countries before having a chance to get practical training in a job in their area of specialization. OPT, also known as optional practical training, is limited in terms of its duration. Moreover, companies do not typically want to hire and train recent graduates only to see them leave after a year or two. Lastly, students who are desperate to get a job in order to utilize their OPT option often settle for jobs that are not commensurate with their academic experience and the area of expertise they are seeking to be trained in. Green card holders can choose from among job offers they receive in their field in line with their career development goals, academic standing. That enables them to make decisions based on position, salary, and geographic location. Why is EB-5 a better choice than trying to obtain an H-1B or E-2 visa? Aside from a limited type of family-based immigration, EB-5 is by far the fastest option of getting US permanent residence status, since there is no quota backlogs. Each country can send 700 applications annually before retrogression. In other words, quota backlogs could become a problem. Of course, that's exactly what happened with applicants from China and to some extent, Vietnam. Candidates from Philippines, however, have no worries now for backlog. You do not need any particular company to sponsor you or give you a job offer for that matter. H-1B is subject to lottery once a year. Generally, there are 300,000 applicants a year for 60,000 to 85,000 spots. The low chance of approval feature of H-1B discourages prospective employers to extend offers in jobs commensurate with your education and experience. They opt to hire potentially a less qualified candidate who is authorized to work in the US. The EB-5 that leads to obtaining a green card provide freedom to study, work, and live in the United States without additional immigration requirements for the main applicant and his/her derivative applicants, such as spouse, unmarried children under 21. It may reduce in-state tuition for the children of the applicants. Last but not least, it provides one of the safest paths to US citizenship. Now what about E2? There is a tremendous misconception that E2 visa is an alternative to EB-5. Since the Philippines is a treaty country, the E2 investor visa is a viable option for the Filipino entrepreneur, corporation, as well as for certain employees of the Filipino national or of a qualifying organization. Remember that E2 in many ways is very similar to the student visa F1 in that it has a definite expiration date. It may be renewed or extended, but the immigration's expectation is that you will leave the United States when your purpose of being here is no longer valid. In the F1 case, when you finish your studies, and in the E2 case, when the enterprise you have established here has reached its goal. Typically, a student who applies early for the EB-5 does not have any need to consider the E2 visa. It's an additional expense that's not necessary. If the student does not have any time left in his or her current F1 visa to stay in the US any longer, then of course E2 can be considered, since this visa typically can be obtained in less than 6 months, and in some cases even faster than that. Once the applicant has secured the E2, he can now apply for the EB-5. This could be done either by expanding the mandate of the E2 enterprise or making a separate investment to a regional center sponsored project. While it might be difficult to change from E2 to an EB-5 direct investment, it is feasible. In order to successfully organize the transition and ensure the EB-5 visa requirements are met, a matter of whole compliant business plan will be necessary. You will also need to hire at least 10 full-time employees. Unlike the regional center model, one benefit of the direct EB-5 program is that there is no sunset date for it. Since you would have already made an investment on the E2, in order to qualify the business now for the EB-5, you would only be required to make up the difference. If you could get the location of the project certified as targeted employment area, then you would need to round up the investment to 900,000. If you cannot do that, then 1.8 million. How can EB-5 investment be funded? What are the main methods to fund the required investment? EB-5 investments can be funded in one of three ways: your own funds, collateralized borrowed funds, gifts. The most common way the student applicants fund their EB-5 investment is through gifts from parents. Parents could fund the gift through their own funds, such as earned income, borrowed funds on a collateralized basis, or inheritance, to name a few. The funds that are invested in EB-5 need to come from verifiable sources. The EB-5 regulations require investors to prove that the investment funds were obtained through lawful means. In other words, the investment funds must not have been obtained through criminal activity. Obviously, in practice, nobody is expecting the funds to be earned unlawfully. But if the funds were earned in cash with no receipts and no tax records, that could obviously become challenging to document. Recently, USCIS has even started asking evidence of inheritance funds to be earned by the deceased through lawful means. The evidence in that case, of course, does not have to be as onerous, but still, the heir who inherited the funds needs to be able to show that the deceased had the wherewithal to be able to earn the funds now being used to fund the EB5 investment. Most recently, on behalf of H. Zhang and M. Hagiwara, their attorney Ira Kurzban argued that not only loans should be admitted as permissible to fund the EB5 capital, but the loans did not have to be secured. Up until this ruling, we have always recommended our clients that while they could borrow money from different sources by pledging their assets such as real estate or marketable securities, unsecured loans were not permissible. This ruling will most likely be very beneficial for EB5 investors with respect to their source of funds. U.S. Citizenship and Immigration Services, known as USCIS, announced new developments under the final rule as follows. As mentioned before, they raised the minimum investment amounts. As of the effective date of the final rule, the standard minimum investment level increased from 1 million to 1.8 million, the first increase since 1990, to account, of course, for inflation. The rule also kept the 50% minimum investment differential between targeted employment area and a non-targeted employment area, thereby increasing the minimum investment amount in a TEA from 500,000 to 900,000. The final rule also provided that the minimum investment amounts will automatically adjust for inflation every 5 years. The final rule also outlines changes to the EB5 program to address gerrymandering of high unemployment areas, which means deliberately manipulating the boundaries of an electoral constituency. Gerrymandering of such areas was typically accomplished by combining a series of census tracts to link a prosperous project location to a distressed community to obtain the qualifying average unemployment rate. As of the effective date of the final rule, Department of Homeland Security eliminated a state's ability to designate certain geographic and political subdivisions as high unemployment areas. Instead, DHS now makes such designations directly based on revised requirements in the regulation, limiting the composition of census tract-based TAs. These revisions helps to ensure TA designations are done fairly and consistently and more closely adhere to congressional intent to direct investment to areas most in need. The rule also revised regulations to make clear that certain derivative family members who are lawful permanent residents must independently file to remove conditions on their permanent residence. The requirement would not apply to those family members who are included in a principal investor's petition to remove conditions. The rule improved the adjudication process for removing conditions by providing flexibility in interview locations and to adopt the current USCIS process for issuing green cards. Finally, the final rule also offers greater flexibility to immigrant investors who have a previously approved EB5 immigrant petition. When they need to file a new EB5 petition, they generally now will be able to retain the priority date of the previously approved petition, subject to certain exceptions. This is a question that we get a lot. How does one pick a project to invest in? What are some of the key due diligence criteria one should be aware of? What's the track record? So these are the questions we ask. What is the track record of the regional center? The track record of the developer? It's very important not to be a guinea pig in a first EB5 project unless you are being compensated very handsomely for the risk you are taking and accepting. How about the I-526 denial guarantee letter? Is there one in place? What kind of a targeted employment area analysis can the regional center show you? Is the developer or some other deep pocket providing a building completion guarantee letter? Is there a senior loan from a reputable lender in place ahead of the EB5? If there is, that means that some professional due diligence has already been performed in the transaction with positive results. If there is no such loan in place, it's possible that the project is so risky that no lender has accepted a senior position in it, and you should stay away from those kind of projects. EB5 investments cannot be made as loans. They have to be made as equity. Therefore, the regional centers need to form a new commercial enterprise, commonly known as NCE, in which EB5 investors typically have a preferred equity position. The NCE lends the funds it receives from the EB5 investor to another special purpose company called the Job Creating Enterprise, commonly known as the JCE. The JCE holds the title to the property to be developed directly or indirectly through layers of subsidiaries it owns. It's important to know if this loan by the NCE to the JCE is guaranteed by the developer or some other deep pocket. In the event of default, after the senior loan ahead of the EB5 investors on the waterfall is paid off, if the liquidation value of the property is not sufficient to redeem the EB5 investors fully, this guarantee would be triggered. Most EB5 projects, unfortunately, do not carry this guarantee. But if a project does have it from a reputable developer or another deep pocket, that's worth a lot. Once the loan by NCE to JCE is repaid, what is the reinvestment, redeployment policy of the region center before the investor files for removal of conditions through filing of I-829 and is ready to receive their funds back? According to the USCIS Policy Manual update from June 2017, investors are now eligible to be repaid upon completion of their 2-year conditional residency period or sustainment period without jeopardizing their immigration process. It is not required for the capital to remain at risk until permanent green card approval. What is the regional center's policy in this regard? Is it revised to reflect the new development? We want them to describe the capital stack. How much senior debt, how much EB5, and how much equity is funding the transaction? We want to know. How does the waterfall work? Is the EB5 ahead of the equity committed by the developer? Is all the required funding to build the project already in place, or raising the EB5 debt a crucial part of the equation? Who conducted the economic analysis and concluded that there will be sufficient number of jobs to enable all EB5 investors to obtain their permanent residency? A more complete list of due diligence questions could be obtained from our website. You see the address there, americaib5visa.com/EB5 due diligence. Now, you could be asking, does it matter where the project is in terms of where you might want to live and work? Why or why not? Because the EB5 program is a federally approved program, as long as the location of the project is in US soil, the state it resides does not matter. The location of the project and where you ultimately would want to live should be decisions you make on a separate basis, picking best of both worlds. For example, you could pick a project you really like in New York City from a risk standpoint, but decide to live in Miami or Los Angeles. Or vice versa. You could pick a project in Miami, but you decide to live in New York or Los Angeles. Now the timeline. How long does this whole process take? Stage 1, standard eligibility tests such as filling out investor questionnaire, understanding the financial obligations, selection of an individual EB5 compliant project, selection of an experienced immigration attorney conversant in EB5, and collecting the necessary documents to demonstrate source of funds. submitting funds into escrow account of the regional center for the project, admission to the fund that sponsors the EB5 project, filing of the I-526 application. This is the first stage. Stage 2, decision on the I-526 application, approval or denial. Thank God, our clients have all been approved so far. Today, this decision is taking 24 to 30 months, in some cases 36 months, or in very rare cases more. Upon approval, submission of the other legal documents such as I-485 in the United States and DS-260 if you would be applying from abroad to get the conditional green card issued. Today, this decision is taking 6 to 12 months, in some rare cases longer. Pass a medical examination conducted by USCIS, approved civil surgeon, as well as biometric screening. Once your adjustment of status is filed, you can apply for an advanced parole travel through filing I-131 document and a work authorization through filing I-765 document. Once your I-765 is approved, that means that you now have employment authorization and you can work in the United States. These documents enable you to remain in the United States, travel and work while your adjustment of status application is pending. 2-year conditional green card is issued, and that's the end of stage 2. Stage 3 is the final stage. 90 days prior to the end of the 2-year conditional green card period, your immigration attorney applies for the conditions in your green card to be removed through filing Form I-829. Recently, USCIS issued a decision that says the sustainment period is the investor's 2 years of conditional permanent resident status. USCIS reviews the investor's evidence to ensure sustainment of the investment for 2 years from the date the investor obtained conditional permanent residence. An investor does not need to maintain his or her investment beyond the sustainment period. So technically, if you have a direct EB5 investment at this point, you can start downsizing. You do not need to maintain 10 employees any longer when I-829 is pending. Most, if not all, regional centers will not return your funds back until I-829 is approved and your conditions from your green card are removed. In the same way, if you are in a direct EB5 investment, although there does not seem to be any valid legal basis, unless you are in a financial hardship, you should hold on the investment and not make any changes. Okay, so let's see how long the whole thing takes. In summary, the I-526 approval and issuance of conditional green card, 36 months. 2-year conditional green card period, 24 months. I-829 approval, 8 months. Return of funds, 6 months. So that total process takes roughly 6 to 7 years nowadays. But that doesn't mean that your conditional, the green card, as we said before, between 2 to 3 years you get it and you can come to the United States. Global tax, we mentioned, and residency requirement of the green card. When more than 2 students are eligible to apply under one application, one or both of the parents need to be the principal applicant or investor. It is possible that some parents do not want to participate in EB5 due to their fear or better yet ignorance about the global taxation of income. Students oftentimes ask if their parents will have to pay tax twice, once in the home country and another time in the United States. The answer is, of course, not. The Philippines and the United States have a tax treaty that is meant to prevent double taxation, which happens when an individual pays full income tax in the foreign country and also pays full income tax in the Philippines for the same income. The treaty allows the taxpayer to get credit for the local taxes paid on foreign income. If there is still some tax due after that deduction, that is when additional taxes would need to be paid. If even this is uncomfortable for the parent, then either they could surrender their green card once their children have their green cards, or they could have each child apply on their own under a separate EB5 application. How about residency requirements? As soon as they get the green card, does the investor need to move to the United States? We get this question all the time. And what's the answer? The answer is again, no. The United States is looking for intent to immigrate rather than immediately immigrate as soon as the conditional green card is issued. The immigration authorities understand that would-be immigrants have businesses they need to wrap up, properties they need to liquidate, and a whole life that they need to transport from one country to the other. The main point is, while the conditional green card is valid, the investors should not be away from the United States soil for more than 6 months continuously. At the minimum, in a given year, they should enter the US a couple of times. What is retrogression? How does it occur? Which countries are subject to it now? USCIS allocates 10,000 visas each year. As long as applicants from the entire world do not exceed this number, there will be no retrogression. However, when the number of applicants in any given year exceed this total allocation, applicants from oversubscribing countries are subject to retrogression. In other words, visa retrogression occurs when more people apply for a visa in a particular category or country than visas available for that month. In simple terms, retrogression means that your funds could be redeployed or reinvested to a new project, subjecting you to a longer wait time for your green card approval. In the last few years, there has been an enormous number of applications from countries such as China, Vietnam, and India. To make room for applicants from other countries, USCIS makes applicants from countries that experience retrogression wait. As far as EB-5 is concerned, there is no retrogression worries for candidates born in the Philippines now. A couple of hot topics that you might have heard or seen in the news: the Bering Regional Center versus Chad Wolf lawsuit. This lawsuit is the second one brought against the US government. Plaintiff is questioning the validity of the November 2020 changes adopted, 2019 changes adopted and implemented. The first lawsuit claimed that the new regulations would cause economic harm. In this second lawsuit, plaintiff is arguing that neither the then acting Department of Homeland Security Secretary Kevin McAlellan nor the then acting DHS Secretary Chad Wolf had the proper authority to propose and then issue the regulations. Greenberg Trauring is representing the plaintiff. This case is of utmost importance for potential investors who have been on the sidelines waiting for the possibility of the required minimum investment amounts to be adjusted down from 900 back to 500,000. They are all asking what the chances of success of this lawsuit are in favor of the plaintiff. According to IIUSA, this is the foremost trade association of the EB-5 business, the court also asked the government to provide a brief on remedies should the motion for summary judgment be granted. This decision may include sending the decision on whether to abandon or reissue the regulations back to the current Secretary of Homeland Security, Alejandro Mayorkas. The court stated if she were to vacate the regulation because she found it was invalid, it would go back to the Secretary, who could reimpose it if he agrees with it. We believe that most likely this lawsuit will be inconsequential. Either the court will dismiss it, or they will not issue an injunction, or will ask the current Secretary of Homeland Security, Alejandro Mayorkas, whether he would reissue the regulations as is. Besides, we have a proposed reauthorization bill by Senators Chuck Grassley and Patrick Lee. If enacted, the bill would reauthorize the EB-5 Regional Center program through September 30, 2026. With the current investment levels, there is widespread industry support for this bill. IIUSA is also championing it to become the law before June 30, 2021, the scheduled expiration of the program. The second topic is about unsecured loans as EB-5 capital. based on the ruling of the U.S. Court of Appeals for the D.C. Circuit on October 27, 2020. This development is probably the most interesting one that has happened in the EB5 market in the recent past. On behalf of H. Zhang and M. Hagiwara, I mentioned before, their attorney Ira Kurzban argued that not only loans should be admitted as permissible to fund the EB5 capital, but that the loans did not have to be secured. As a result, on April 14, 2021, USCIS approved his client, Mr. Zhang's I-526 petition. Okay, what's the best way to reach us? If you have follow-up questions after this webinar, you could email us at info@americaeb5visa.com, or you can WhatsApp us at 1-917-355-9251. Thanks for your participation. We would very much like to hear from you. Please do not hesitate to write to us or call us. If you have any questions, I will be more than happy to answer. Please don't be shy. Any question is a fair game. I don't claim that we will know the answer to all your questions. If we don't, we will research and get back to you.
Okay, wow. Very interesting.
It is.
Okay, I have a question, Mr. Isever.
Please go ahead.
Okay, so the investment is $900,000 to 1.8 million, right?
If it is a TEA, the project is in a TEA neighborhood, it's 900,000. If it is not, 1.8. On a practical matter, regional center projects now, 95%, if not more, are being structured in TEAs. So let's say that it's 900,000.
Okay, and then the first stage is 24 to 30 months. And I also saw that not all, what do you call that, applicants can be approved. They can still be denied, right?
Yes. So
Not because someone has the money, they can be approved, right? It is still subject for approval.
So this is an excellent question. In fact, this is the question to ask, and I'm so happy that you asked the question. On a practical manner, there are two reasons why an applicant could be denied. The first one is project related. If the project cannot create the required number of jobs, meaning 10 plus jobs, then of course they will be denied. Most of the time, you can enter nowadays to a project that has already created the jobs. So that possibility goes away. You can enter it to a project which is what we call exemplar approved, I-924 exemplar approved. What that means is that if the project does what they are claiming to do, then the jobs will be deemed to have been created, which means that the project says, I'm going to spend $500 million, $500 million. And if they do spend the $500 million, then they're not going to count each and every job that was created. They will assume because the money has already been spent, the jobs must have been created. So that's why the business plan is very important. That's why the due diligence of these projects is of utmost importance. Number
All right,
two,
thank you.
I'm sorry. Number two, you could be denied because of the source of funds. And that is really the job of the immigration attorney. The immigration attorney will give you comfort that your source of funds is solid. Before you get a solid source of funds confirmation, my recommendation is that you should never send the money to the escrow account. But once your attorney approves your source of funds, then the possibility of rejection is almost zero.
Thank you. Thank you so much, Mr. Isever.
My pleasure. Any other questions?
So, any questions from our friends? Yes, go, Ma'am Nolly Chua.
I wonder if you do feasibility studies for the business that is supposed to be set up. do you do consultation, or do you do this type of work for people who'd like to invest 900,000 or more?
100%. We look at the projects, and we analyze the projects, and we have a huge spreadsheet where we ask the questions. Actually, if you go to our website, www.america EB5 Visa, you will see an article there that was published, that I wrote and got published in EB5 Investors Magazine, where we are explaining the art of picking the right EB5 project. So we explain there how is it that you should be selecting a project, what is the analysis that you're supposed to be doing. So obviously, we work with solution partners in order to come up with the ultimate answers. But the answer to your question is 100% yes.
Thank you.
Sure. Any
Sir,
other question?
can I ask a question?
Yes, Danilo.
Oh,
Yeah, is that one of the compelling reasons why they invest, aside from the prospect of U.S. citizenship, the potential huge profit from out of a real estate investment or from a business to be set up? Is that the main compelling reason, aside from, of course, from the citizenship?
That is also an amazingly good question. The way I want to answer that question is that there is really a triangle here. And the triangle has three vertices. One is the government, one is the developer regional centers of partners, one is the investor. Each one is getting something and giving back something. Like, in other words, each one is earning something and giving back something. The government is really giving up green cards. Obviously, they're just giving green cards to all these foreigners. But what are they gaining out of EB5? Jobs. So if you make the calculations, minimum 10 jobs per investor, we're talking about 2,500 to 3,000 investments for 10,000 visas. You can calculate how many jobs that is. A lot of jobs the government is creating in the country. The investor is getting a green card, but in return are getting below market investment rate. So the answer to your question is that investors would not do this to earn a lot of money. They would do this to get the green card for the US citizenship, and they're giving up some money, like some return that they could have made if they didn't get the green card. So of course we can help investors to invest in the United States. We have a lot of projects that do not come up with a green card, and they will obviously earn much higher interest rate, much higher returns. And lastly, in the vertex, in the triangle, there is the developer / the regional center. They are obviously getting a better, funding rate. That in fact, most of the EB5 projects right now refinance mezzanine debt, the middle debt. So they could be paying a little bit higher rate. They will refinance with the investor. What are they giving up? There is a lot of work. In order to be able to get into the EB5 business, these regional centers have to go through a lot of paperwork. They have to be approved by the U.S. government. So that's the trade-off. I hope I answered your question.
Yes, thank you.
Any other question? Maria?
No?
Oh.
Everything is clear. Perhaps when we have the money to invest, then we will go there and get a green card. Or probably not a green card, but to make money out of our investments.
Absolutely.
about CP Danny? Well, I know CP Danny is not leaving the Philippines anytime in 5 years, but would you like to add something, CP Danny?
Oh, you're always putting on the spot, huh?
Not really.
Because I was really thinking, why say a Filipino who can actually travel and live in the States, say for at least 6 months, will really invest for a citizenship if there's no compelling reason to live. Like you can enjoy, say 900,000 US dollars, converted into peso. It's kind of huge already in the Philippines, and you can live a comfortable life. That's why I'm asking, what are the other prospects? That's my,
Yeah.
my
I want to
yeah.
answer that question. I want to answer the question. I briefly touched upon it in my presentation, but basically,
Ah,
U.S.
teka
education
lang.
is not cheap. U.S. education today is probably 250,000 to 300,000 to get a bachelor's
Mm,
degree. You make the calculation. It's
mhm,
70,
mhm.
$75,000 a year. You multiply by 44 for a bachelor's degree. You'd be lucky if you can finish that with 250 to $300,000 for one kid.
Oh.
If you have more than one kid, two, three kids, you're already out almost $1 million. And
Mhm.
you know, when they went to Harvard, Yale, Princeton, MIT, and I know Filipinos are, you guys are very smart. That's where you go. I mean, I know all these colleges, they are full of Filipinos. Now, when they get this incredible US education, after that, what are they going to do? They want to work in Microsoft. They want to work in Apple. They want to work in Google. They want to work in Amazon. The list goes on and on. JP Morgan, you know, they want to work in an American company and complement the amazing education they got with work experience. They can't. They will work maybe for a year OPT. If they are STEM, they'll work for 3 years. Then they got to go back. So this program gives the
Mhm.
opportunity to these students, for example, to be able to get a job, the best job in the United States, work for
Mhm.
3 years, 5 years, 8 years, and combine the theoretical education that they got with the practical work experience and mesh it together, and they become, you know, what you really want them to become back in Philippines. Then they can go to
Mhm.
Manila, they can go to wherever, and they will be, you know, top executives. Otherwise, they go to these schools and they get all this theoretical information. They can't work here, and they go back to Philippines. You know what? They won't be able to get a good job. Like they would still go like a entry level job. So what did you accomplish? You spent 250,000, 300,000 for per kid, but you know what did you accomplish? You know, so I think because of that, this investment, my personal opinion, is the best gift a rich parent, you know, of course you have to have the money, a wealthy parent can give to the kids in addition to the education. Because
Mhm.
you know, the last thing you want, you send them the kids to United States and then they come back and they're unemployed. I mean, this is
Mhm.
ridiculous. Can you imagine, you know, going to Harvard, Princeton, Yale, and not being able to find a job, or you find a job but not really, you know, but when you come back with a, you know, Microsoft, Apple, you know, that kind of a work experience on top of the MIT, now you're talking. Now in Philippines, you get any job you want at the
That is
highest
right.
level, you know. So that's
Mhm.
the reason. It's not, everybody thinks that the reason why you want a green card is so that you become a US citizen and you say bye-bye to Philippines. No. That's not the
Mhm.
case. You want to you know, get a complete education, and that's why. Now some families might, I mean, some families might want to immigrate to United States. Obviously that's possible, but most of the time, if you look at the statistics, 80% of EB5 is done by students who are either directly investing themselves
Mhm.
or they are going with a parent, because there's an advantage to going with a parent. Because if there are 2, 3, 4, 5 kids, big family, everybody goes with one application. So then you
Mhm.
amortize the money. Now with one investment, everybody is getting a green card. Um, and as I said in the presentation, the parent can stay with the green card. If the parent is uncomfortable with the U.S. affiliation, the taxes, whatever it is, they can just give the green card back. So the parent can give but the kids will remain with the green card. They will not lose
Yeah.
the green card.
Wow.
It makes sense now?
Yeah, it makes sense.
Okay. Okay.
Thank you.
Allow me to talk. This is Alex. I just want to appreciate the eliteness of this speaker. I know
how hard to get or even to graduate in Wharton, because before I studied just an online course. It's so challenging. And now I'm taking advanced digital marketing course in Wharton. So I know how elite this speaker, and we are so blessed to attend on this quality quality public speaking. And my question, another note, before I used to create branch for Philippine companies, mostly in Hong Kong. Could I how to get a visa? Do I need to get an investor visa? But this is for my clients want to create a branch in US promoting products here, products made in Philippines. Is it
So in other
investor
words,
visa?
can you make a company in the United States, or can you have a subsidiary of your Philippine company in the United States? Is that the question?
Yes, yes. Do
100%.
I need? I'm just a CPA working for a company, representing a company to create a headquarter or branch, just like I did in Hong Kong. So do I need what are basic requirements like a letter from the go ahead, sir, go ahead.
So there is absolutely no problem in creating a company, especially because we have the treaty anyway, the E2 treaty between United States and Philippines. So there is absolutely no problem in you creating a company here and working in that company. I'll tell you even more. Those of you who are married, something that very, very few people know. If you have an E2 company here, and let's say the spouse or the other one owns the E2 company, the spouse can work anywhere they want. Like for example, the one of the spouses becomes the owner, or at least 50% owner of the E2 company, and then the other spouse can work anywhere they want. I can speak to you offline, Alex, if you are interested in this. We'll be happy to guide you and introduce you to immigration attorney here as well that we have relationship with.
Thank you so much, sir. Thank you so
No
much.
problem. My pleasure.
Well, that was a great interview, Marco. And a lot of our Rotarians are really interested. In fact, some of them are messaging us, watching from our Facebook Live. So really, we're going to invite you in our Facebook members page so that they can continue this conversation with you. But in the meantime, Marco, the Rotary Club of Alabang Madrigal Business Park would like to thank you for really giving us this honor for speaking tonight with us at this live online Zoom session. We hope to have you again in the near future so that people would really be enlightened by the things that you're saying. Really crystal clear. Thank you very much. Ladies and gentlemen, a warm round of applause to our speaker, Marco Isaver. Thank you, Marco.
Thank you,
Thank
sir.
you, Marco, Mr.
Thank
Sever.
you.
Thank you so much.
Thank you. Thank you so much.